CeCe, they came at you today. 4 witnesses. Witnesses 2, 3, and 4 were all supposed experts in genealogical DNA or whatever you call it. And they were attacking the process that this was not done the right way and to different degrees should be excluded. What do you think?
Well, I didn't see how any of it was directly relevant to this case. None of them had any information, as far as I could tell, about how the investigative genetic genealogy was done in the Kohberger case. If they are questioning genetic genealogy's reliability, which it certainly appeared that they were, we have proven its efficiency and its reliability in over 800 cases now, where a DNA sample has been positively identified, at least in part, thanks to leads generated through investigative genetic genealogy. But like I always say, all of this really is irrelevant because it is simply a tip. It is not going to be used against anyone in a court of law. It is not evidence. It's not exculpatory. And so in the end, it's the DNA match that they got to the admissible genetic evidence that is going to be used against him.
So let's just bootstrap that, and then I want to go and give Geragos a chance on the other side, of course. Paul Callan, good to see you, brother.
Hey, good to see you.
To CeCe's last point, okay, fine. Feel any way you want about genealogy DNA. We got the swab. We matched it just the way we always do. It's you. You're done. Why isn't it as simple for the prosecution?
Well, I think in some respects you could make that argument, but understandably, this is a death penalty case, and the courts are usually pretty open about discovery in a case like this, where the stakes are so high, and they want to know how did the FBI build this genealogical tree that led back to Pennsylvania, where they got the swab that linked him to the Idaho murders. And I think the jury probably is going to want to know about that too. So if the prosecutors did it in a reliable way, if I were the prosecutor, I think I'd want the jury to see, at least in general, how that trail was established.
What's the best hope here, Mark Geragos, on this issue of the genealogical part, when you know they have the swab to do it the regular way they do it?
Well, look, the problem is going to be, before you can introduce a novel DNA methodology, you have to have a hearing. That's why we have a hearing. Everything that CeCe says is correct, that maybe it's tips, it's not going to do this, not going to do that. You still have to do you have to get it admitted. You have to show that it's acceptable in the scientific community. And by the way, if it doesn't meet muster, if it doesn't raise to the level where a judge finds that this is generally accepted in the scientific community, it can be excluded. If it's excluded, then you have a domino effect as to everything else that happens after that. So I wouldn't be as dismissive of this. I've mentioned this to you before, Chris. 25 years ago, I did the hearing with mitochondrial DNA before it was admissible in California. That was a week-long hearing. They flew in people from D.C. and have to do that hearing. The law requires that you do that. You can't just get up and say, hey, we did this, it's a scientific test, trust us. That's not how it works.
I get it, but just give me one more beat on this, and I want to move on to another aspect of it. If they have the swab and the swab matches what they found on the sheath, then who cares about the genealogy aspect of it? You want to throw it out, fine. It wasn't the only thing we had that we were looking at him for, because we had the car, we had other stuff. But on the DNA part, fine. You don't like the genealogy, it doesn't matter. We got it the regular way.
Well, because the defense is going to deconstruct everything that's happened. First of all, they're going to talk about the car. They're going to say, no, first time they had the car, they had the wrong year. They then went and reverse engineered it. Second, when they got to the sheath, they didn't have any exemplar or anything. They ran it through. It didn't come back with a hit. The only way they got to the hit was, the defense will argue, an unreliable, unsanctified, if you will, or unsanctioned scientific methodology that doesn't pass muster. And then they may arguably do a motion to exclude based on that. That requires quite a bit of a judge to do or a judge to exclude. I don't think that will necessarily happen. But as Paul said, it's a death penalty case. You raise every single issue, because if you don't, and there's a conviction, the first thing that they're going to do is they're going to allege ineffective assistance of counsel against the defense for not doing these things.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find News Nation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of News Nation's fact-driven coverage.